So, hi everybody. Welcome to this event. When can courts constrain authoritarian governments? We're very excited to have our panel here today, panel of speakers. We have today Professor Yvonne Tew, Professor Sergio Verdugo, and Professor Julius Yam. Professor Julius Yam. It should be a very interesting discussion today on authoritarian governments and authoritarian regimes and the place of courts in the context of authoritarianism, and whether they can constrain and when they can constrain authoritarian power or not. And for today's discussion, just to introduce our speakers, so I'm Yasser Qureshi. I'll be the chair for today. And just to introduce the speakers, Professor Tew is a professor of law at Georgetown University Law Center, and she is the author of Constitutional Statecraft in Asian Courts that came out a couple of years ago as an exciting and excellent book, very relevant to the topic of discussion we have today. And her scholarship has been published in several major law journals, as well as in book collections from Oxford University Press, Cambridge University Press, and her expertise is in comparative constitutional law and religion from a global perspective. And then we have Professor Verdugo, who's an associate professor of law at Universidad del Desarrollo in Chile, where he serves also as the director of the Center for Constitutional Justice, and he's also an editor of the International Journal of Constitutional Law and the Secretary General of ICON-S. And he works in subjects such as political theory, constitution making, and works in constitutional courts and democracy. So looking forward to him having his thoughts today, presentation today as well. And our discussant today is Julius Yam, who is a assistant professor from the University of Hong Kong, and he's also completing his DPhil here at Oxford. And he studies constitutional law and courts from an interdisciplinary perspective. And he's also a research associate with the Program for the Foundations of Law and Constitutional Government at Oxford. So the way we'll hopefully manage the event is we'll have our panelists speak for 15 minutes each. And I will let them know as we get to the 15-minute mark so they can keep a track of time. And then we'll have Julius present some thoughts and discussion points for our panelists, which they'll have a chance to respond to, and then we look forward to having everybody's questions from the audience on the different aspects of today's discussion, right? So any questions? Otherwise, with that, I think we can get started. I guess we can start with Professor Tew.
Wonderful. Well, thank you so much for this opportunity to speak to you today. Thank you, Yasser, and thank you to Tarun and Kate for this opportunity. I'm delighted to be part of this conversation with Sergio and Julius, and indeed like everyone on this panel and at the Bonavero, whose work has been so generative in developing my own thoughts. So I'm really looking forward to the discussion on when can courts constrain authoritarian governments. I'll say at the outset that my remarks today will be drawn from my recent book, Constitutional Statecraft in Asian Courts, which was published in 2020 with Oxford University Press. And I'll also say a little bit about a forthcoming article on strategic judicial empowerment that I have also been working on as regards to questions that are relevant to our discussion today. But to begin, let me start with sort of setting out the main premise of my book and the ideas that I think will feed into our discussion on whether courts can constrain authoritarian governments. And the main premise of my book is really that courts in Asia, and with a specific focus on common law Southeast Asian states like Malaysia and Singapore, can and should, I argue, play a stronger and more assertive role in helping to both build and protect resilient constitutional democracy. Now, of course, especially in authoritarian or dominant party contexts, a central question is then, well, how do courts in these fragile or dominant party contexts effectively assert judicial power, particularly when confronted with consolidated or dominant political parties? And so I also seek to give an account of how what I call judicial statecraft is needed for these courts to sometimes incrementally, sometimes strategically build their own institutional power. My focus on the Southeast Asian states of Malaysia and Singapore in the book provides what I think are in-depth examples of two of the clearest exemplars of two regime types that are common across Asia. So on the one hand, we have a dominant party regime, which has always been controlled by a single political ruling party, as in the case of Singapore. And on the other hand, as in the case of Malaysia, we have a much more currently fragile democracy that has only recently emerged from dominant party rule to a political order that, as of now, currently remains very much in flux. So in such context, a dominant party system or even a fragile democracy, can courts constrain authoritarian governments? And we start, of course, with something of a paradox, which is that most modern constitutions in the 20th created in the 20th and 21st century, including Malaysia and Singapore, specifically empowered their courts with powers of what we might say strong judicial review. In other words, these Asian constitutions have constitutions that empower their judiciaries to invalidate laws and executive actions that violate constitutional guarantees. Yet in practice, historically, the courts in these Asian states have traditionally been highly passive, deferring extensively to political branches, resulting in de facto legislative supremacy. And part of the reason might be the influence of British legal traditions, given these post-colonial contexts, including the notion of parliamentary sovereignty, of course. But the political context of a dominant party system has also clearly played a role. Since gaining independence more than half a century ago, Singapore and as recently as 2018 in Malaysia have both been governed respectively by a single political party. And the ruling party has also typically controlled more than 2/3 of the legislative majority. And that number is significant because that's the threshold required to amend most provisions in the Constitution. And the government has not hesitated to use this power in the past. For example, in 1988, the Malaysian government amended the constitution to remove the textual provision that judicial power is vested in the courts, making it instead textually dependent on federal law, i.e. the legislature. So in the face of such consolidated political power, the judicial task of these Asian courts have often been described as hopeless or Sisyphean. Many scholars have argued that judicially enforceable constitutionalism is unsuitable for contexts like Malaysia and Singapore, and instead they argue that because Asian courts operate in a context of such consolidated political dominance, judges should avoid exercising strong judicial review and instead be deferential in order to avoid provoking political confrontation. So that is not my view. I argue that courts in these contexts should adopt a more empowered judicial role, even or especially in the face of dominant political power. The question then, of course, is how courts in these fragile or dominant party contexts can assert such power. So now to turn to the fascinating question, I think, of when can courts constrain authoritarian government? Is judicial empowerment futile under these challenging, fraught political circumstances? I don't think so, but I do think that a fragile court can transform itself into a more assertive one. However, it must do so strategically. Courts in fragile democracies must use a certain amount of statecraft in asserting power. By establishing the foundation for judicial empowerment carefully, sometimes incrementally, so that it can assert power or authority in future confrontations with the political branches. And to illustrate, I'll use two landmark decisions by the Malaysian Federal Court, the highest court in the land, in 2017 and 2018, to illustrate some of what I'm talking about. So let's start with a 2017 case called Semenit Jaya. This case involved what apparently looked like a seemingly prosaic matter of land acquisition compensation. And in that case, the Malaysian Federal Court not only unanimously struck down that land acquisition statute as unconstitutional, which was the first time in 20 years that it had struck down a federal law, it also laid the groundwork for a power to declare constitutional amendments unconstitutional. The court specifically took on the 1988 constitutional amendment, removing the text vesting judicial power in the courts, and explicitly declared that Parliament, to quote, does not have the power to amend the federal constitution to the effect of undermining the basic features of the separation of powers and the independence of the judiciary. This is a huge step in terms of the assertion of judicial power for the Malaysian federal court that had, up until this point, been far more passive in its assertion of judicial power. And several features about this case are striking. I mean, for one, the court stopped short of actually invalidating the constitutional amendment outright. Yet in broad reasoning, it articulated an immensely powerful doctrine, one of basic structure, that empowers the judiciary essentially to declare or nullify constitutional amendments as unconstitutional. Another curious feature is the remedy that was issued by the court. The court invalidated the statute, but held that its decision would only have prospective effect. So by explicitly stating that its decision would apply only prospectively, the court mitigated the impact of its decision by insulating the immediate decision from immediate political or public backlash. Much like Chief Justice Marshall, one might say, structured his opinion in Marbury v. Madison so that there was nothing for the Jefferson administration to defy. And finally, the court did all of this in what seemed to be a seemingly mundane case. I mean, the Land Acquisition Act case was not, at least at first glance, a sexy, blockbuster constitutional law case that attracted lots of public attention. The court could have avoided addressing the broader question of the constitutional amendment on judicial power. Yet the court chose in this case to deliver a fairly narrow holding, while at the same time managing to embed the seeds in its reasoning for a broader expansion of judicial authority. The year after, though, in 2018, in another case, Indira Gandhi, the federal court then consolidated its assertion of judicial power in another, what was to become another landmark case. And this time, this case, Indira Gandhi, involved one of the most contentious issues in Malaysia, religious authority of civil and religious courts. The court in that case unanimously declared the judicial review power of the civil courts to be part of the basic structure of the Constitution. And in doing so, in effect nullified another constitutional amendment that had previously been read to prevent the civil courts from reviewing decisions of the religious Sharia courts. And remarkably, the court did all of this in a case that dealt with what is a fraught area of religion. So if Samania Jaya in some sense can be thought of as the Marbury v. Madison equivalent, then Indira Gandhi might be its Cooper v. Aaron, and astonishingly sort of happened within the time span of a year. But these decisions show a court that strategically, in a multi-stage process, was beginning to establish and to strengthen its judicial power. So how do courts engage in more robust review once they have asserted their judicial power? In my book, I outlined several doctrinal judicial tools for courts seeking to constrain dominant political power. One such tool, as we've just discussed, is a doctrine of unconstitutional constitutional amendments, a doctrine that, applied at its most robust, courts could invalidate constitutional amendments that it finds violates the Constitution's basic structure as unconstitutional. But courts could also use this basic structure doctrine to interpretively nullify amendments, as the Malaysian Federal Court did in its 2017 and 2018 decisions. I mean, a second tool that courts could use is that courts could develop a more purposive approach towards interpreting the Constitution's structural and rights guarantees. And courts should be conscious, I argue, about crafting the values and principles that form the foundation of the constitutional order in order to construct a culture of constitutionalism, particularly in fragile or developing democracies. And then third, I argue for a greater use of proportionality analysis in rights review. A judicial balancing analysis could replace the traditional deference doctrines that these courts have tended to use and empower courts to assess government restrictions on rights in a robust yet flexible manner. At the same time, the sort of malleability of the proportionality analysis allows courts in challenging political circumstances to incrementally adjust and develop a doctrine that they can later wield with more fully to constrain government actions. In sum, these judicial tools, I think, provide appropriately robust but flexible forms of judicial review that can be used not only in democratic hedging, but also in democratic building. So before I wrap up, I want to just also then say a little bit about my new piece, Strategic Judicial Empowerment, which is forthcoming in the American Journal of Comparative Law, and it's available now on SSRN. The paper engages broadly with the question of how courts use strategy for their self-empowerment and explores several such techniques across a range of global contexts, including Pakistan, Malawi, Malaysia, even the UK. It explores several strategies, but the two primary strategies are ones that I will call Maximalism and Minimalism, which I want to say a little bit about because it relates to this question of how courts can build power to constrain powerful political actors. First, on what I call Maximalism, courts may issue a maxi-minimalist decision. This is essentially the Marbury strategy, right? Which features broad maximalist reasoning expanding judicial power, even as it results in a narrow holding that often defers or avoids immediate legal or political consequences. So you see this, for example, in the Malaysian court case that we just discussed, laying down a power as far-reaching as reviewing unconstitutional constitutional amendments, yet not actually invalidating the constitutional amendment in the first instance, but waiting to assert this power in a subsequent case, which it did the following year. You see this also around the world in the case of Pakistan, which Yasir will know much better than I, the Pakistan Supreme Court case in 2015. In India, before, we've seen the maxi-minimalist move in several strategies in which a court with more fragile power will initially lay the foundation before building on it. And inversely, the second strategy is that of mini-maximalism. So courts may use the inverse strategy of taking a mini-maximalist approach that seeks to downplay its judicial assertion of authority with formalistic reasoning presented as thoroughly orthodox doctrine, even as it delivers a highly consequential ruling, right? And I won't go into it in detail here, but by recent cases, perhaps even the UK Supreme Court's decision in Miller 2 arguably offers an example of this. It's also worth noting that these two strategies, maxi-minimalism and mini-maximalism, are often used in sequence. Courts around the world tend to first issue a maxi-minimalist decision, laying the doctrinal groundwork with expansive reasoning in a ruling of limited consequence. Then once that groundwork has been laid, later issues a much more consequential decision, entrenching its judicial authority that is portrayed as simply following already established precedent. And in the piece, I also consider other strategies, which I won't go into now, strategies like coalition building, the use of popular rhetoric, the optics of a unanimous decision. And I'm happy to return to any of these in the discussion later. But in drawing this talk to a close for now, to return to the question of, can courts constrain authoritarian governments? I want to end on a note of cautious optimism. Fragile courts, I think, in Asia and elsewhere, to be sure, face special challenges. And to be clear, I do not subscribe to a Dworkinian vision of judges with Herculean wisdom, judges as Hercules that valorizes courts as saviors. But at the same time, while I don't think of judges as Hercules, neither do I think of them as Sisyphus, condemned to a hopeless task when faced with powerful political actors. Courts can, and I argue should, play a part in constitutional state building in these aspiring yet deeply fragile democracies. And there are some indications, I think, that in at least some Asian contexts, of judges that are taking steps along the path toward a more robust judicial role. As for the question of when can courts constrain authoritarian governments, I think that is a complex and fascinating question. And as I have described, I think that a fragile court can transform itself incrementally into a more powerful one, but it must do so strategically. And not all judicial wagers for power pay off, of course, but a court that seeks to strengthen its institutional position judiciously, carefully, and strategically may find itself poised to emerge from institutional battles for power with an enhanced position in the constitutional order. I'll stop here and I look forward to discussion. Thank you.
Thank you, Professor Tew. That was a really interesting presentation and plenty of interesting points. We're looking forward to going into more detail on in the discussion. I'll bring on Professor Verdugo, if you'd like to go next.
Thank you very much. I would first like to thank Yasser for moderating, Julius for commenting. Yvonne, it's a pleasure always to hear your presentations, and to Tarun and Kate for the invitation. I'm very excited to be here. So my presentation is based on, well, something that started in my doctoral dissertation, but in two papers that I published last year. One was published in an edited volume by Ido Porat and Rehan Aveiradne on towering judges, and the other one was published in the Columbia Journal of Transnational Law. They both used the Chilean case along with other examples, mainly from Latin America, to try to tackle parts of this question. I don't think that this question has yet been replied in a holistic way, but the literature is advancing fast, and there are many examples and experiences, and of course Yvonne's work has been very important about that. So I think that the question of this panel is situated in two types of discussions that are interesting for my own research. First, there's a descriptive and an explanatory question. What can courts do against authoritarian regimes? This question is broader compared to the question of this panel, as it does not necessarily interested in the problem of constraint, how to constrain the regimes. Courts can do different things, and even if a ruling doesn't have the capacity to constrain a government, it can still be beneficial. I want to make this point before going into my argument, because I think it's sometimes overlooked in the literature, and I think something worth exploring. Let me just suggest two hypothetical examples. During an authoritarian regime, courts can investigate human rights abuses. Doing this, they may first raise visibility to a problem, second, provide a forum for discussion regarding an issue that the regime prefers not to discuss. Then the court can collect documents, testimonies, among other pieces of evidence that can be used later. They can be used for historical purposes, they can be used by activists, researchers, and those materials can stay until the right time to release them arrives, and they can also be used in international forums. So still, the rulings of the courts may not be enforced, and courts may face backlash from the incumbent regime as a result. But that doesn't mean that the ruling is useless, because the ruling can be invoked by the opponents of the regime to denounce it. The regime's reputation cost may be heightened if the regime has built a narrative around the rule of law, for example, and the ruling may put the regime leaders on the spot by making a contradiction visible. So even if there's a problem of constraint or enforcement, the rulings can still be useful. And we need to keep this in mind when we advise judges what to do, because sometimes scholars have in mind the idea that, if your ruling is not going to be enforced, maybe it's not worth to do it. So there are at least two common arguments for preventing judges from taking this kind of action. So first, the backlash, right? They may not be renewed, they may be exiled, they may face wrong accusations, their powers can be reduced, other courts can be created to compete against them. Think, for example, of military regimes empowering military courts, etc. Less visible measures can also be taken against judges, like threatening reducing their salaries, harming their careers in the future, etc. However, one can respond to this argument by identifying the alternative ways in which judges will lose authority if they don't act, which can also happen. I will speak a little bit more about this later. Second, judges are typically incapable of advancing relevant democratic values by themselves. This is a very normal argument. If you see, for example, Tondali's book and others, they will, most of them will claim, judges are incapable of doing it. The literature on political fragmentation, for example, such as the studies of Ramsayer and others, show that the political competition and alternation in power is relevant for judicial empowerment. When political systems are competitive, judges will have more space to judge freely because they will always have a relevant political opposition to the regime to support them. Dixon and Ginsburg call this a double insurance when judges use it, showing that they can rule against both political parties that are competing. But the opposite will happen when the regime lacks political competition, cases of dominant party regime or hegemonic party regime. In these scenarios, judges cannot be expected to enjoy a big amounts of material power because it will always be harder for them to team up with other actors because there are no other actors, at least at the domestic level. But this is not to say that the battle is always lost. There are networks of human rights institutions in and outside the country that can still be used. So sometimes I argue it's still worth trying. And this leads us to the normative question, which is the question that I'm more interested in. Is it worth it? Judges are probably taking a risk by performing these actions. Should they take those risks in? What can they do? So some scholars have suggested that judges should act strategically. I call these strategies survival strategies. They can ignore the problems, hide under a bunker, wait until the storm passes. They can use weak judicial review strategies, such as Garbaum has suggested. Others, for example, Issacharoff, Delaney, Dixon, they suggest a number of avoidance strategies, postponing decisions. It's very common to speak about the Marbury decisions. In these Marbury decisions, Yvonne already explained them. They can issue narrow rulings on limited grounds while planning a seat that they can, of an argument that they can use more strongly later. Even though these strategies may help judges to preserve some of their authority, parts of their authority, or at least hide a possible attack against the judiciary, I argue that these strategies are not necessarily empowering for judges. Sure, they can help plant the seed and ask the judges to choose their opportunities to intervene more wisely. But when judges use them, they're not only losing a battle, they're also showing that power is unconstrained. So I suggest that when facing the dilemma of becoming irrelevant actors for the regime and employ a surviving strategy, or trying to enforce democratic or liberal principles against the regime, judges that are interested in preserving their authority should try to predict the outcome of the case, how the outcome will look like before making the decision. We need to consider that in this scenario, the judge's authority always possesses some degree of risk. On one side, if judges decide not to intervene, they will show that their behavior is shaped by external actors, allowing their independence to be undermined. Sure, they can explain their avoidance or postponement on formal grounds. They can claim, for example, that they are denying jurisdiction on a technical requirement that the legal action doesn't meet. They could claim that the problem was not their authority, but the formality. Judges may feel comfortable with this strategy as it allows them to keep an appearance of performing their functions apolitically. Lisa Hilving has shown how and what are the costs of doing this. Combining these types of judicial apoliticism with an authoritarian regime may result in judges not only preventing a dubious action from being controlled, but also by ending rubber stamping those actions. In this case, judges may not only be passive observers, but they can also be blamed by helping the regime. We should always distrust when authoritarian leaders try to protect independence. They have reasons to do so. Many scholars have shown that the authoritarian regimes care about problems of control and power sharing they develop a language of judicial independence because of this. They can use courts to monitor and information gathering mechanisms. They can use superior courts to discipline lower courts, to make an institutional or a rule of law promise credible, to attract investments, to solve intra-elite conflicts, among others. The appearance of judicial independence doesn't mean that independence is real. If judges are pressured not to rule against the regime, they are not truly independent. And this won't only depend on the specific legal and formal design of the judiciary, of course. In other words, my argument follows from the fact that judges may face a tragic dilemma with risky options. When deciding which option they should take, if the risks are equally important, they should prefer the option that advances democracy after careful consideration. What I propose is a framework that judges can use for this goal. Parts of this framework is by no means novel. I mean, it builds from insights that are already present in the literature. The notion is simple. In short, the framework suggests that judges must identify and predict the regime's expected cost of disobeying a judicial decision. If the projected costs are high enough, then the regime's leaders might prefer to comply with the ruling. In their landmark paper of 2001 on the role of courts in the maintenance of democratic regimes, Lee Epstein, Svetso, and Jack Knight have suggested to focus on what they call the regime's tolerance intervals. They follow the logic presented by Eskridge of the associated cost of tolerating a judicial decision that is not on the regime's ideal point. A more contemporary paper authored by our co-panelist, Julius Yam, invites us also to distinguish the levels of political stakes that each case involves. Examining the case of Hong Kong, Yam shows that cases involving lower political stakes for the regime have better chances of getting a ruling that will go against the interests of the regime. Using Epstein's, Sova, and Knight's language, the tolerance interval is higher in those cases. Thus, a key thing to do is to identify what defines a political stake as high in the case of an authoritarian regime. Persecuting a political leader of the opposition, striking down a statute that is crucial for the regime's policies, for example, may be of a high stake. An LGBTQI plus case may be very important for us, but perhaps it is not very important for a conservative-driven regime that prefers to pick its legal battles in issues that are more fundamental for their maintenance of power. Identifying when the political stakes are high is probably a contextual question, though. But we can assume, I suppose, that maintenance in power is more important than, say, a lower regulation of tax law. If the regime is desperate to attack investment, probably property rights are more high stake than other matters as well. What is hard is to identify a strategy that judges can use when the stakes of the regime are too high. This is the hardest case. So if the political stakes are high, then what judges can do? I suggest that even in these cases, it is possible to employ a strategy. It won't work always, of course, but I think that this is a strategy that is worth considering. I claim that this situation is possible. Of course, I identify one possible scenario in which this can happen. Is a paradox for the regime, it's a dilemma for the regime. The paradox consists of a dilemma that dictators face when they are forced to decide whether to support the constitutionally rooted institutions they themselves have established, or to disobey the unfavorable decision while risking to divide the regime's supporting coalition, harm their own credibility, or weaken the legitimacy or authority of the regime's institutions. As a tool of judicial statecraft, the paradox raises the cost of the regime of ignoring any single judicial decision, and those costs may be sufficiently high to pressure autocrats into acquiescence. I develop an example in which this situation took place in the 80s. The example took place in Chile, when the Constitutional Court, which has been created by the Pinochet regime and packed with regime-friendly judges, decided to strike down a provision that was crucial for Pinochet's interests. Pinochet had planned the 1988 plebiscite, in which Chileans were going to decide whether Pinochet was going to remain in power for an additional 8 years. The conditions were favorable for Pinochet, who was convinced that he was going to win the elections. Many political rights were limited, institutions were favorable to the regime, the campaigns were organized in a one-sided way, and of course, funding was uneven. More importantly, for the purpose of the example, is the fact that Pinochet had planned for the electoral court to be implemented after and not before the plebiscite could take place for the next elections of the Congress, and not for the yes or no vote of the plebiscite. The plan also included other rules involving financing and creating new political parties, the powers of the director of the electoral agency in charge of overseeing the process, among other rules that were inclining the field in favor of the Pinochet allies. The constitution of the regime that was created in 1980 by the same regime had empowered the junta to regulate all of these aspects by enacting organic laws. The Constitution also had a transitory disposition explicitly establishing that the electoral court was going to be established after the plebiscite and not before the plebiscite. The organic laws, by design, were supposed to be revised by the Constitutional Court, following the French model of ex-ante abstract control. It was a strategy aimed at legally rubber stamping the main legislative decisions of the junta. And if Pinochet left office in the future, the strategy allowed for a Pinochet-friendly court to control future legislators before enacting those laws in these sensitive matters. The court however, the court acted in an unpredictable way. The court used the opportunity to strike down crucial provisions of the organic laws regulating the plebiscite, forcing the regime to implement the electoral court before and signaling the opponents of the regime that the conditions of the 1988 plebiscite were going to be different from the ones that operated for the 1980 plebiscite. The opposition won the plebiscite in the end. In 1980, Pinochet had popularly confirmed his constitution with undemocratic conditions, but those democratic conditions could not be completely replicated in 1988. So the question is, why did the junta send the legislative acts to the Constitutional Court, and why Pinochet obeyed the decision of the court? The fact that the court itself was a creation of the junta, that the court used norms included in the constitution, and the fact that some civilians of the regime were supportive of the decision, some had even suggested those norms before in the committees advising the junta, elevated the cost of ignoring the decision by putting in danger the authority of the Constitution itself. The Constitution had many other things that Pinochet and his allies valued, such as amnesty laws and the power of the military. Having lost the plebiscite, Pinochet did not want to undermine those things. He indeed then modified the Constitution so that the military could get more autonomy. So the stakes were high, the costs were high enough to push Pinochet into accept the ruling. That's why I think this is a very unique example that can suggest a future line of research to show and to keep identifying conditions that will help courts to act nonetheless, even though the conditions are adverse and the political stakes are high. Thank you.
Great. Thank you so much, Professor Verdugo. Thank you for two excellent presentations, and I'm sure we're going to have very interesting discussion with great questions. But first, we'll turn to Julius for his point of discussion, and he'll present his thoughts and comments, and then we look forward to your responses to his comments. Take it away, Julius.
So hi, everyone. Thanks for the wonderful presentations, Yvonne and Sergio. And thank you for the Bonavero team for getting us together. I mean, there's so many interesting things to talk about when it comes to this topic. But I mean, I only have 10 minutes today, so I'll limit my discussion to perhaps two issues. So I won't be really commenting specifically on the works by Yvonne and Sergio, but rather I'll have a more general discussion about the current state of affairs of this field, this study of courts in authoritarian regimes. So there are two things that I would like to talk about today. So first is sort of why is studying courts in authoritarian regimes from a normative perspective a challenging but also worthwhile endeavor? And second, since I'm from Hong Kong, I'll also talk about what Hong Kong can bring to the table as a case study in this aspect. So first, I mean, a lot of research in the field are descriptive or explanatory in nature, as Sergio has already explained, focusing on sort of how courts actually behave in authoritarian regimes. I mean, these works are of course important, and as many have shown, courts in authoritarian regimes don't behave in the same way. So sometimes we have courts that actually can constrain authoritarian governments, as today's presentations have shown. And so I think the next logical question that needs to be answered in this field is, how can courts constrain authoritarian governments, which is part of the topic of today? And ultimately, this is the question that really matters to many of those living in authoritarian regimes. And it's also a challenging question because commitment to values such as liberalism, constitutionalism, or even democracy goes against the very spirit of an authoritarian regime. And in this regard, we're fortunate to see more and more works coming out trying to provide solution to judges about how this can be done, learning from case studies. So for example, Yvonne suggests using constitutional doctrine strategically, or what she calls constitutional statecraft, or as Sergio points out, courts can sometimes decide or position in ways that make it politically costly for authoritarians to attack courts. I mean, in the law and social inquiry piece of mine, I've also suggested tools for courts to strike a balance between promoting liberal democratic values and preserving institutional strength. And of course, this is something that I'm working on in upcoming projects, including my thesis. Or even as Yazzer shows in his work, sometimes it's about judges knowing the right people, having the right connections, would really help judges in authoritarian regimes to survive or even thrive. So my point here is simply that I think it's encouraging and even healthy to see an increasingly normative focus on the study of courts in authoritarian regimes, and that we are now not only interested in the descriptive or explanatory aspects. I think the normative questions are the more pressing questions, the questions that are really in need for answers. So my second point for today is on Hong Kong. I think Hong Kong is really an interesting case study for the purpose of this discussion. And for those who are interested in this topic more broadly, there are good reasons, I think, to study Hong Kong. And there are two reasons for this, I think. So one is Hong Kong has always been an authoritarian regime. I mean, but perhaps unexpectedly, we see a court that has been quite assertive for around the first 20 years after the handover of Hong Kong. The court has been the main driver of liberal values in Hong Kong, and developments in human rights issues are attributable to the Hong Kong courts. So my colleague Eric Ip described the Hong Kong courts as, quote, the only political organ that has ever succeeded in continually resisting Beijing in the constitutional history of the People's Republic of China. I mean, quite an achievement considering the power imbalance there, a local court versus one of the largest political parties in the world. But more relevantly, I think there are many lessons we can learn from this case study, Hong Kong, for those who are interested in answering this question we have today. I mean, several of us here in Hong Kong has written about this, but we can also see Yvonne and Sergio's insights being played out in Hong Kong, this kind of constitutional statecraft maneuverings, sort of using proportionality doctrines strategically, as well as sort of courts taking advantage of weak points of the authoritarians, sort of Sergio's insight there. So I think this just goes to show that the applicability of the insights of existing works may have greater reach, and that we should try to learn more from each other, to engage with other jurisdictions so as to help us answer the question we have here today. A second reason I think Hong Kong is interesting is because throughout post-handover Hong Kong's constitutional history, we actually see sort of two different regime periods. So the first is the first 20 years or so after the handover, where Hong Kong was perhaps best described as a hybrid regime. So it was still an authoritarian regime, but we see sort of semi-competitive elections and a commitment to liberal values despite a lack of democracy. The second period is Hong Kong since 2019, where we see Hong Kong experiencing a sharp authoritarian turn. The 2019 protest, as well as the enactment of the national security law, led to a much more direct authoritarian control over public institutions and even civil society. So for our purpose here, for the purpose of comparative constitutional studies, what is interesting here is that the structure and composition of the Hong Kong judiciary have largely stayed the same. So the main changes are only the outer environment, the regime politics part. So technically, we still have the same judges here, the same sort of savvy, principled, resourceful judges in Hong Kong, or at least that is how they were thought of in the past. But it seems that these same judges' behavior have also changed accordingly. So a colleague of mine has criticized the court for not being, quote, adventurous enough under this new political climate, and accused the court for not staying committed enough to liberal values. So I think this phenomenon here is interesting and illustrates two broader points, I think. So one is, although we have reasons to be optimistic about the potential of courts to constrain authoritarian governments, we can't be too carried away and still need to remember that ultimately the potential of the courts is to a large extent limited by regime politics, limited by factors that are beyond the judge's control. And second, under a very, very authoritarian environment, strategies of the court might need to be recalibrated. So understandably, the Hong Kong courts seem to be retreating now, taking more of a deferential position. We can, of course, discuss to what extent it should compromise, but I think it's clear from comparing courts in these two periods of Hong Kong that different kinds of authoritarian environments give rise to different needs, and accordingly warrant different responses. In authoritarian environments that are more forgiving, it's worthwhile to ask how can courts constrain the government? That is really the focus of today. But in more authoritarian environments where political space is super limited, perhaps the real question is sort of how can courts preserve powers so they can live to fight another day, to use Ross Dixon and Sammy Zakharov's terminology. So the broader point here is that what judicial strategies or judicial responses are called for depend on the specific configuration of the authoritarian regime. There's tremendous diversity in authoritarian regimes, and we might need to disaggregate the different kinds of authoritarian regimes if we want to move forward as a field. So that's all I have to say for today. I hope this is helpful. I look forward to the questions, and thank you.
Thank you so much, Julius. That was some really interesting comments, and I'll leave it to our panelists to take some time to respond to them. And in the meantime, while they respond, for everybody, if you have any questions for our panelists to discuss them, please post them in the Q&A. And then once they're done with responding to Julius, I'll start introducing those questions and asking them directly from our panelists. Thank you. I'll leave it to the panelists to respond to Julius.
Thank you, Julius. That was a very in-depth and insightful survey of the field. And of course, Hong Kong is such an interesting and complex case study for the questions that we are discussing here. I could say a few general things in response to Julius, but I'm also happy to take more questions first. What would you think would be the best way forward, Yasir?
I think it would be good if you took a couple of minutes to first respond to Julius, and that conversation can become one that generates more questions, hopefully from our audience as well. So,
okay, that sounds good. Okay, so like in responding in turn to sort of Julius's points, I think I'll say two broad things in response. Like the first on the state of the field, and I think this is the question that obviously, that I find fascinating, sort of the ideas about courts and how they constrain authoritarian regimes, the idea of how the field has shifted from descriptive questions to, as Julius put it, more normative ones. I think that's certainly the case, and it's especially the case if we look more broadly at the political science literature as well as the constitutional law literature, right? When I was kind of looking through the landscape of accounts of essentially comparative judicial politics, and I'm sure this is an area that all of you are incredibly familiar with. On the one hand, I think I was struck by certainly like a lot of valuable work that has been done, mainly by political science scholars, of judges who are seeking to act by maximizing their own policy preferences. Essentially, judges are rational choice actors seeking to maximize their own policy preferences or interests in a manner that is determined by the political context, right? So that's one sense of like of where the field has come from. On the other hand, I sort of see myself situated between that account, which is in many ways like a more descriptive account, and one that sees judges as dealing with external political regimes and acting in a rational choice manner in approach to that. And between that and also on the other hand, this internalist constitutional theorist account, which is more familiar to legal scholars, at least traditionally, that tends to view constitutional adjudication as based on normative legal principles or legal values, and the idea of judges creating, a constitutional theory through internal normative values. And both of these accounts, I think, grasp important dimensions, but at the same time don't fully account for, I think, the kind of judicial strategy that I talk about, and which many of you are looking at, which is, I think I view courts as at once both political and legal actors. So in some senses, judges are of course political actors seeking to strategically negotiate their position vis-a-vis the other government branches. But importantly, while judges operate within a particular political setting, they nevertheless have the space to exercise agency as legal actors. Courts are situated and perceived within a constitutional order as legal institutions, ultimately, and their strategic choices therefore have distinctive meaning as legal actors. And that is why I think I'm interested in how courts embark on employing self-empowering legal tools that enhances the judiciary's institutional power against other branches of government. And I think like in this sense, I think, and to answer, I think one of the questions I saw pop up just now by one of the audience members, that and so the socio-political, of course, the socio-political context does matter for judges and how they are situated. But at the same time, I don't think the socio-political context is the entire story, right? I think there is some degree for judges to negotiate within even a constrained socio-political context. And while also recognizing the limits to complete judicial agency, and Julius's point here on the move from hybrid to authoritarian states and the various constraints is, of course, well taken. The second point I will make, and this brings in the Hong Kong point as well, the Hong Kong case study as well, is the importance, I think, for all of us in the comparative constitutional law field of always being context attentive and context sensitive. I think like many of these accounts that we all look at very sort of nuanced, in-depth case studies of particular contexts. And of course, to some extent, there may be some value when it translates to a different context, but there is no sort of one-size-fits-all answer or formula, I think, for the question of when or can judges constrain authoritarian governments. I think it's imperative for each of us to be very conscious of the context in which particular courts are operating in. And in various systems, I think different tools might be more or less helpful. When you speak about Hong Kong, I often think about one of my colleagues and scholars in the field, Po Jin Yap, who has also written on Malaysia, Singapore, and Hong Kong, where he advocates a much more dialogic approach, what he calls a dialogic or weak form judicial review approach for courts to adopt in these kinds of systems. And insofar as courts are able to develop greater constitutional engagement through the use of such dialogic or sub-constitutional tools, they should do so. Perhaps particularly in the case of Hong Kong. My argument is simply that in certain situations, there is also value, I think, in the judiciary asserting its authority to protect core structural principles or rights guarantees. And so my sense of how courts in these situations do so is it's really more to give an account of how courts might, in some cases, strategically assert power in fraught political context, but also so recognizing that various socio-political contextual factors are certainly contextual features that courts have to be very conscious of and to navigate around. So I'll pause here.
Thank you, Sergio. You have any?
Yes, thank you so much, and thanks to Julius for his comments. I think he elaborates well on what is the state of the field now. It feels that the political science literature and the legal scholarship literature are finally
I think there might be something slightly wrong with Sergio's internet.
Yeah, Sergio, I think he might have frozen.
Hopefully he'll come back in a minute. Well, while we wait for his return, I can while we wait for his return, I can start. Maybe I'll bring up the question that I think Yvonne, you had
Sergio
briefly.
is back.
Sergio is back. Great.
Yeah, I'm so sorry. My
No problem.
connection seems that it's not. Yeah, no. So I was saying that that there's finally, I think, a literature that is talking to each other more, but I still think that there are certain differences that make the comparisons across case studies difficult. Which is the kind of things that they focus. So Julius, for example, he's expecting more the strategies, and people doing game theory and looking at separation of powers games in the judiciary tend to do this a lot. But there's another literature focusing on judicial culture, and there's another one focusing on the politics of the internal politics of the judiciary that we haven't looked enough. That's my impression. And this literature on the internal politics of the judiciary is driven also by judicial leaders within the judiciary that I don't think we yet understand so well. That's why the edited volume on Towering Judges has been very important, to my opinion, because of that. But how to weigh those? So just to give an example, I'm not an expert in Japan, but I'm interested in the Japanese case. I cannot read Japanese though, but I have read about what explains the conservative nature of the Supreme Court of Japan since the Kempo Constitution was established. A Kempo Constitution that was supposed to be more liberal, right? It was supposed to establish courts that were supposed to enforce rights, but it didn't. So some scholars think that this is because of the dominant party regime that has been held in Japan for a long time now. Others focus on the incentives that judges have. Some judges do not last very long. They have culturally, they want to move out. They want to go to the cabinet committee, or to other places. And some are saying, this is a matter of culture, judicial culture, the civil law tradition, the fact that they feel that this is a weird thing to do, to revise the legislative statutes of the political regimes. So how to weight these different explanations is something that I think the literature has yet to do more. I feel that, especially I'm using the Japanese case because I have read competing alternatives that are not dialoguing well, I think, among themselves. I find the regime politics ones more persuasive, but how to weigh the others in and how to exclude them, I don't think we know enough. And the literature is not there yet. This is one of the things we need to do. The other question that I wanted to pose, it's more of a question than a comment, is how are judicial doctrines relevant, right? So this is what legal scholars have focused more on, the types of judicial, and as Yvonne does, right? The types of judicial doctrines that are more relevant for judges dealing with authoritarian regimes, which is something that typically the political scientists neglect in their own writings. And how are they really relevant for the regime politics? Are they reading the arguments of these decisions? Are these decisions helping the judges to make a claim that they're doing business as usual? Is it a matter of consistency? Because many times when judges need to face a regime, they need to be creative, right? They are dealing with a law that is typically on the side of the regime. So if they need to strike down that law, they need to develop creative tools. Sometimes showing business as usual won't be a possibility if they want to face the regime, or if they want to use the legitimacy of the law, and I mean the legal legitimacy in Fanon's language, on their own side. So I think there's a conundrum there that Yvonne has contributed a lot to our understanding of that conundrum, but I still think that there's a lot to be done there.
Great. Thank you. Those some very interesting comments. And I thought that since Yvonne, you partially responded to one of the questions, I'll just ask that question from the audience, and then everybody can take maybe, if for anybody who has a response to that, I'll just ask it. So this comes from Jan Petrov, who says, Yvonne, Sergio, and Julius focus most on judicial agency and strategy. However, the question also of how costly non-compliance is for the rulers also depends on how relevant audiences value compliance with judgments, which in turn rests on historical and cultural factors. So my question is, how do you envisage the relationship between judicial strategy and the surrounding socio-political environment? So whoever wants to address that further.
So I have a quick response to that. So sort of ties to what I think Yvonne had just said. So I'm sure sort of strategies is a very contextual matter, that some strategies would play out in environment A and some strategies might work well in environment B. So let's take this example of rhetoric, right? So the Indian courts or the Pakistani courts, as Yazim must know, uses a sort of very populist rhetoric. And this has often been described as a strategy for the courts to connect to the public, sort of by the basically by the support of the public, sort of get people excited about the court's judgment, et cetera, et cetera. But you can also sort of imagine how that strategy will definitely not work in, let's say, Germany, where the culture there is sort of more technical, more formalistic, has sort of drier approach to writing judgments. So I think definitely that's judicial strategy is sort of highly contingent upon the socio-political environment that the court is situated in. And sort of echoing Yvonne's point just now that perhaps strategies, there won't be sort of one fit for all sort of strategy or toolkit, but the most we can do is sort of explore more and more tools that are available to judges and hope that some might work in certain environments, sort of increase the chances of success of these judges. So that's sort of my response.
Sergio, Yvonne, you have anything to add? Or? The question, sorry, yes. I think Sergio couldn't hear the question properly, so I'll just say it again. The question was, how do you envisage the relationship between judicial strategy and the surrounding socio-political environment? Yes, continue, Yvonne.
I was just going to say that I think some part of this, I don't want to take too much time because I feel like I addressed some of this in my previous comments, but to pick up on what Julius has just said, that certainly some of those other strategies are bits that I look at in my piece on strategic judicial empowerment. So this idea of a court being very cognizant of its audience. And so you do see in some courts in Malawi, in Pakistan, in other places, this popular rhetoric. I think we call it popular rhetoric as one of the judicial strategies that a court might use to build sort of public salience. Now, on the other hand, the mini maximalist strategy that I talked about earlier might well be a court, like in the case of the UK or other places, like Julius pointed out, maybe Germany or other places, of a court using formalist, sort of legal, doctrinal language in order to ground what is ultimately quite a vast expansion of judicial power, because the way for that to take salience in a particular constitutional or legal culture is to be cognizant, I think, of the audience in which the court operates. And the audience could be popular, it could be the public, it could also be legal, it could be the academy, it could be other judges, it could be other lawyers, and I think that's something that courts take into account. One other strategy that I'll mention is one that I might call coalition building, and that is when a court takes into account the other institutional stakeholders. And by that I mean, for example, a court is trying to build a coalition with, say, the legislature against the executive, for instance, might then in its judgment use rhetoric that suggests that its decision is very much about protecting, say, Parliament from, say, against a prorogation, by the executive. And in a case like that, like a court is sort of reaching out to create, I think, an alliance with other political stakeholders in a context where that might against a powerful other branch of government. So I think there are many different ways in which a court can use various ways to consider its socio-political environment. Unanimity, again, like in some contexts, you can imagine a unanimous court being absolutely crucial for a decision to be accepted or to be legitimized by the public. On the other hand, in other contexts, dissenting judgments are a way in which various judges on a court might well build, salience both in the legal and the public eye. So I think, again, back to the point of it being important for us to consider the various contexts in which these decisions take place, but at the same time being very cognizant also of the audience to which the judges reach out to is important.
Yes, so I agree with everything that has been said. I have a question though regarding the unanimity rules that Yvonne was suggesting. So it seems to me, I also think that dissenting opinions are very important. Sometimes a majority decision in favor of the regime will have a dissenting opinion against the regime that we want to make it visible, and there's something valuable there that we want to use in the future as well. So I wouldn't suggest to have anonymity to the decisions anonymized, as some countries do. I think if unanimity is going to be used, it should be something spontaneous that judges agree on, and it can be helpful, but there should always be a space for dissent. Actually, dissenting opinions that are in favor of the regime can age very badly, and this is very good for normative purposes to have those decisions, so we can have our strawmans to battle against. That helps to show how the world in the past used to be when we remove obstacles that are important. Regarding the audiences, I think that the audiences that judges can have can be broadened. Here there's something that scholars can actually do. I have seen that many judges are part of international networks. Some of them, they want to be appointed eventually in an international committee. They want to go to the Venice Commission. They want to be part of the Inter-American Commission on Human Rights and so on. And these international networks are not only useful for coalition building outside the domestic jurisdiction, because they can also link them with NGOs and so on, but they're also useful for building larger audiences that can broaden the scope of the careers of judges in the future. So a judge can champion democracy and human rights in a place in the world and pay a lot of cost for that, but it can gain a lot of benefits from it as well if the audience is sufficiently broadened. And this is there's a space here that I think hasn't been, I mean, it's ongoing, but I think scholars could and academic associations could do more about this.
Great, thank you. Well, we have a bunch of more questions, so I'm going to start, and then hopefully we have 10 minutes. So, if we keep the responses quick, that way we can get through as many of these as we can. But it's great to see so many questions for the audience, for our panelists, and discuss. So the next question comes. A couple of questions come from Louis Peraza, who asks, being an autocratic leader, how do you avoid measures to will decide higher issues in the authoritarian leader's favor? As Nicaragua, with the 5th mandate of Ortega, will the judges not be appointed? Judges appointed by Ortega have any chance to decide these freely? And then in Hong Kong, can the UK and its judges do more to defend the democracy left, at least for 50 years, as the Chinese-British agreement established? So I'll leave it to the speakers to respond.
So I'll just answer the Hong Kong bit first. So about basically foreign judges in Hong Kong, what's their role now? So I mean, for those who are following, this is a huge ongoing debate as to, basically the debate is whether they should resign or whether they should stay. I mean, so it's an ongoing debate, as I said, and it's quite controversial, but I do think that there are some things that these foreign judges can offer. I think, as Sergio was saying, sort of networking and the sort of benefits that are underappreciated, such as moral support. So having sort of peers that are willing to support you during perhaps challenging times, it's something that is perhaps underappreciated. I think that you want to feel that you have overseas colleagues here, judges from other sort of more reputable courts overseas, sort of here, still willing to work with you, so not abandoning you. I think that's a strong signal, as well as sort of moral support that these foreign judges can offer. And also, I mean, even courts in democracies face challenges sometimes, face constraints sometimes. And so having these judges on board on the bench as well sort of can also provide perhaps useful or even practical insights to the Hong Kong courts in case they need these insights to sort of navigate these environments. So I tend to think that there is something that these foreign judges can offer.
Great, thanks. Sergio, do you have anything to add? Or first question about judicial appointments? Any thoughts?
Yes, so I was looking at the question. So I think the question by Jan Petrov have already been addressed. I agree with him that audiences are important and socio-political environment is very important. The question by Luis Peraza on Nicaragua, so it needs more context. I need more information to be able to answer the question of whether judges will have the opportunity to decide freely. But I agree with him that this is a very adverse case for judges that were not appointed by Ortega in the case of Nicaragua. I would start by taking cases in criminal law. I think to start small, I would suggest to explore those types of cases and start there. I would also suggest to look at the audiences of those judges that were not appointed by Ortega if we want to do something with them, right? But just by the information I have now, I cannot reply to the question of whether they will be able to have the opportunity. My guess is that they can also look at institutions designing the same Sandinista constitution to look for opportunities for creating a paradox. But I'm rushing this answer. I don't know the answer to that question without looking at the case study.
Thanks, Sergio. So on to the next question. This is from Shukri Shahizam. The question is, a lot of the discussion about judicial empowerment is about how the courts as an independent actor can constrain the executive and legislature. But how should we account for courts themselves having an ambivalent attitude about their role in constraining the other branches? So Yvonne, would you like to take this question?
Sure. So absolutely, judicial self-perception or judicial will is crucial. It's a crucial element, right? And I think ultimately that is one of the things that my book's account seeks to elucidate, which is that it's much less about the descriptive question about whether and how courts do these things, although it certainly is interested in that too, but it's very much like creating an account of why courts should, and if they should, then in what circumstances can they do so. I think that I'll say a couple of things using the Malaysian case study as an example here of a court that may or may not have an ambivalent attitude, if I may, given that I know that Shukri is interested, is a scholar working on Malaysian courts as well. So I think I'll say two things. One is that the story of the Malaysian judiciary, but really I think this is a story of many judiciaries around the world towards what we might say a court that's willing to constrain other branches, is and has always been somewhat uneven. It's a story that zigs and zags, right? There's a 1 step forward, 2 steps back, 2 steps forward, 1 step back story that we can see across lots of fragile democracies, whether that's Malaysia, Hong Kong, Pakistan, Latin America. And so I think like that's very much the case that we might see this sort of apparent judicial either assertiveness, or in some other context then some judicial restraint, or even some judicial, as this question puts it, judicial ambivalence, right, towards constraining other branches. I think certainly as a court goes further along that journey, it's sometimes obvious to see splits in the court, and I think that's very much certainly the case in the current Malaysian federal court, Malaysia's top court. I think it's worth noting that a lot of sort of recent cases, even those that in which it may have seem as if the court takes a step back, those are split decision cases, and so you see sort of two sort of intellectual camps in the court, perhaps one in which the judges are pretty ambivalent about their role in constraining the political branches, and then another branch of the judiciary that is clearly sort of trying to invest it in upholding the precedents, the robust precedents that they have, assertive precedents of the court before, and in pushing forward. And of course, underlying all of this, back to the socio-political climate, in a fragile climate, political climate, in which I think Malaysia is very much the case now. We've had like 3 different prime ministers in the last 2 years. It's very much a fragile political context in flux, unlike, say, in contrast, Singapore, that has still, maintained its dominant party system throughout. I think a ruling party that no longer holds unassailable dominance is one in that kind of political system. The court has a lot more room to maneuver. It also gives different judges more flexibility and room to push particular agendas forward. And this is the second and final point I'll end on. Again, back to the point of the account that the book is a normative one. It's not just about what judges are doing, but what judges should do. And it is primarily focused on also, and part of that account is to tell judges that they are already on the path of constitutional statecraft set out in the book. And these are the tools in which judges might use in countering the ambivalence either of the court as a whole or their colleagues, in then pushing forward along a path towards a greater assertive role for the courts in constraining the political branches. So I'll stop there.
Thank you, Yvonne. And I'll just ask if we have 1 more minute, so I'm just going to ask a quick question, a couple of questions that sort of combine the last couple of questions together for you to respond to. So the first is from Florence Lee, which is, would human rights be a useful judicial tool to use in court? So human rights law or principles, or does it have a weaker bite in tackling or impacting authoritarian courts? And then from Professor O'Regan, the question is, what role does the legal profession play, or should it play in affecting how courts behave in authoritarian societies? I leave those final questions for however you want to respond.
Yeah, I would like to take the first question, if you don't mind. So first, there's a legal distinction that we need to make, right, which is the status of human rights in the specific jurisdiction. If the status of human rights is of a binding nature, and there's a regional regime with where we can formally say that there's a source of law that we can enforce in the courts, there will be more arguments to make human rights claims in that regime more legitimate and to put the regime in trouble, right? But even if that is not the case, I think it's still useful to use human rights as a tool. And for that, I think judges can understand how the human rights narratives work in the naming and shaming, right? So human rights are not only about getting decisions against the ones that are responsible, but they're also about identifying, making a problem more visible, and shaming the responsibles for that. And in this strategy, courts can play a role, right? They are not the only ones. We have NGOs, we have other regional institutions that can work, but judges can provide a forum to make these cases more visible, even if the decisions in the end are not enforceable or whatever. But they can be used as a tool, and I would suggest to actually bring those narratives in case of authoritarian regimes. I think they can be very, very helpful.
Yvonne, Julius, any final thoughts on this question, and then we can wrap up.
So just a quick word about the sort of role of the legal profession in sort of protecting courts or sort of strengthening courts. So I mean, in an upcoming project of mine, as well as in my thesis, I sort of developed an audience-based framework, sort of identifying constituencies, external constituencies that can empower courts. So yes, I do think that there are a sort of bunch of constituencies or audiences, depending on how you see it, sort of have specific roles to play in protecting, strengthening courts, or even sort of shielding off attacks from courts. So the legal profession is one of the most important constituencies, obviously, partly because they are the ones that are able to speak to the legal language, so they can sort of decipher what the court's saying and sort of transmit these messages to other layman constituencies, but also sort of they are at the front line of the law, right? So they know the law the best. They understand the system the best. So they have the credibility to speak on these matters. So obviously the legal profession, or even legal academics, are sort of close allies of the court. So even in authoritarian environments, so take Hong Kong. So the legal profession in Hong Kong has always been very supportive of the court. And some have argued that this is at least one of many factors that the court were able to sort of do what they wanted to do, sort of commit themselves to liberal democratic or liberal constitutional principles, because they have these important allies on their side. So yes, so I do think that sort of having key actors, having the right connections, having the right allies on their sides really matter, especially in authoritarian environments where politics or socio-political factors play a larger role.
And just very quickly to answer the question on the role of proportionality as a constraint on authoritarian governments, I'll take it one more meta step up and just talk and say that maybe it's not just about proportionality or even the doctrine of unconstitutional constitutional amendments or purposivity or any of these tools that we've talked about. I think another way of putting this is that it's not the case that, you know, the tools by themselves do magic work. And I think that ultimately these adjudicative strategies are exactly that, right? Tools or strategies. And the tools on their own don't do magical work, but they can be helpful and effective strategies for judges, especially, and this is back to the point of judges with a sense of judicial self-perception of wanting to constrain the political branches. In those cases then, I think in the hands of capable judges who are looking for ways of performing their role along the dimension of constraint constraining authoritarian governments, then these are tools that provide, I think, both the robustness and the flexibility for judges to use to good effect. And I think like that is perhaps like the overarching point that I will end on.
Thank you, Yvonne. I think that's a great point to close our discussion on. Thank you so much for participating today, to the panelists, for your wonderful presentations and discussion and responses to the questions, to the participants, and audience members for all your questions and your attention. And I hope you all enjoyed this event. I really learned a lot from our panelists, and I think that we can end it there. So thank you so much, everyone.
Thank you. Thank you to all of you at the Bonavero Institute and at Oxford too. Thanks for having us.